Good afternoon, everyone. Welcome to Walker Morris and our webinar on untangling, words right, untangling the red tape of international trade. I'm delighted to be joined this afternoon by Claire Burrows, who is a director in our regulatory team, and by Nick McQueen, who is a partner in our commercial disputes resolution team. I'm Andrew Northage. I'm the head of the International Trade Group at Walker Morris. We decided to do this webinar on the back of a report that we've had commissioned called Made for Trade. And one of the pieces of data that stuck out to us from the report was that 93% of the respondents to that report saw opportunities in international trade, but 87% experienced challenges with red tape around it. Now, we can't discuss all of the different requirements for all different categories of products just in an hour. We'd need a day or more just talking about food, never mind medicines, medical devices, cosmetics, toys, chemicals. That's just to name a few. There are lots of different regulations that apply, but there are certain regulations, Claire, that apply no matter what.
Yeah, absolutely. So there are certain elements, as Andrew said, that will apply in all cases. Obviously, there's numerous considerations, but some of the key things that are going to apply no matter what product you're dealing with are moving products across borders, so import and export requirements, and getting the right people in the right places, so immigration requirements, and then how you legally place your products on the market. Obviously, different jurisdictions have got different requirements, but there are some overlapping regulations, although there can be some stark and subtle differences. Ultimately, planning in advance is key.
And could you give us some examples of the sorts of differences you see?
Yeah, absolutely. So, for example, one of our food sector clients recently has been looking to expand from the US market into the UK. They've got a food product that's got a specific ingredient in that's FDA approved, absolutely fine in the US to be marketed under its common name. But in the UK, the requirements apply for it being a food additive, which means there's specific requirements in terms of packaging and labelling. So the product has to be referred to by its legal name. It's also got to have its E number after. So it's not a big change, but it's just something that needs to be updated on the packaging before it can be placed on the UK market. One of the other things we noticed when we were looking at that particular incident was the marketing claims that were being made. Under UK consumer protection law, there are specific requirements about health claims. So we had to make sure that they were compliant with the regulations in the UK as well as the US. Ultimately, I think knowledge is power. So making sure you've got specialist advice from people that understand your business objectives, your sector, your product and the jurisdictions is really key to success.
And that different to the man that was in the news last week with his cake sprinkles that he got very upset about.
Yes.
That wasn't us.
No, not us, not us.
So taking the example of placing products onto a different market or indeed multiple markets, what are the sorts of things businesses should be thinking about?
So first and foremost, what are you selling? What jurisdiction are you planning on selling it into? And then what regulations apply to those products in those jurisdictions? Obviously, they're the key building blocks in every circumstance. And once you've got those, you then need to establish where in the supply chain you actually sit. So are you a manufacturer or a de facto manufacturer, which means you sell products somebody else makes but under your own brand? Are you an importer? Are you a distributor? Are you an authorised representative? You can fulfil multiple roles under the regulations, so you just need to understand where you fit in. Once you've worked that out, you can then work out what commercial agreements you need to put in place to affect your supply chain. Under some regulations, you can't place products on the market in a particular jurisdiction unless you're established within that jurisdiction or you have an authorised representative. So for some of our clients, they set up a subsidiary in the right jurisdiction. For other clients, they use a third party to fulfil that role. It's essentially just for consumer traceability for both the regulator and consumers in case there's any issues. There's a point of contact in the right jurisdiction, essentially.
And you've seen this recently with a particular client you've been working with?
Yes, so one of our clients is a US-based client. They have been acquiring medical devices from various jurisdictions around the world, and they've been storing them in a distribution warehouse within Europe. The products are then sold, the contracts are agreed with the US parent company or client, and the products are then sold and shipped to various clients within the EU and also the UK. So obviously there are a number of overlapping requirements, and they were a little bit befuddled about what they were supposed to be doing in which case, particularly because some of the customers that were buying were wholesalers and some were end users as well. So the way we overcame this was essentially creating a supply chain map. So what are we doing? Where are we selling things? How are we selling them? Who are we selling them to? And then overlaying that with the different requirements so that they could make sure they're compliant in all of the various different supply chain scenarios that could occur.
So that sounds like something that would be quite useful on a general basis.
Absolutely.
To map that out.
Mm-hmm.
Thanks, Claire. That's really helpful. So turning to you, Nick, obviously Claire's given us a flavour there of some of the regulatory frameworks and some of the things that you can do to map out different roles and responsibilities. But if we turn to customers and supplier relationships, what should businesses be considering from a contractual perspective when they're looking to trade overseas?
So I think when parties enter into new agreements, obviously at the start they are focusing on the positives, they're excited about the new opportunities to work together, and they often don't actually like to address what happens when things go wrong. However, inevitably things do go wrong, and I think it's always key right at the outset to consider what contractual provisions can be put in place to deal with those scenarios. It's especially a case where there may be a supply chain and risk can be passed up and down the supply chain. Really working out there, where's liability going to lie? Where is the risk going to be? So it's things about thinking right at the outset, are you going to have limitations of liability? Are you going to put in place things such as warranties and indemnities? So again, where there's a supply chain, parties often will agree indemnities, but it's worth remembering an indemnity won't stop you being pursued. It just means that you can pursue someone else as well for that loss. And also, if you're dealing with companies that may be based in different countries, then it's worth considering, well, how would you enforce any warranties or indemnities? So if there's issues about enforcement, it may be that, again, you've got to look at the contract and think, well, how can we minimise that risk? How can we minimise that exposure? And again, it's thinking about what contractual mechanisms can be put in place, or is there various types of security that can be put in place? So it may be that you agree things such as a performance bond, or you try and get some form of insurance.
And I think, again, on indemnities, it's worth remembering as well that an indemnity is only as valuable as the money that's there to pay it out.
Exactly.
Which, again, as you say, particularly if you're dealing with a business overseas that you don't know so well, you can't perhaps do quite so much diligence on it. And a performance bond might be one thing to think of. Could you just talk us through how a performance bond works?
Yes, I mean, there's various different types of bonds, and obviously you have to assess all the individual circumstances. It's effectively a guarantee that comes into play in case there is non-performance. So they're often a bank guarantee or some financial institution guarantee where the bank is based in the recipient's home country. So if it does need to be enforced against, you can have on-demand performance bonds, which could just be called against in certain conditions, or it could be that even if there's a formal dispute and when it comes to enforcement, that you can enforce against the bond rather than going to the company's local country and having to deal with the local enforcement.
Thank you. And thinking about as well, what about agreeing the law that applies to the contract and how you'll resolve disputes? Presumably that's important as well.
It's very important. So again, right at the outset of a contract and entering into a new agreement, you need to consider which law is going to govern the contract. But as you say, also what jurisdiction, if a dispute does arise, will that be resolved in? So I think obviously English law is fairly popular. It's a fairly safe choice. Again, the English courts are often a popular choice in international supply contracts, as is arbitration. And with a London seat, they're very popular. And the London Court of International Arbitration, they have their own rules, obviously, as well, which are a popular choice. We'll often act for clients where there's actually no link to England whatsoever, either party or in the contract. So recently I've just been advising some companies based in Eastern Africa who have been supplying goods to Switzerland, where their counterparty is based in Switzerland. The goods never come anywhere near England. The parties haven't got any base in England. And again, they've chosen English law in that circumstance. Where the dispute should be resolved as well, and the jurisdiction, again, it's key to really agree that so you don't have satellite litigation and issues where you are then challenging jurisdiction. Again, recently we were acting where there was a distribution agreement where it was between England and Northern Ireland, which are different jurisdictions. And proceedings were one party issued proceedings in England, one party issued proceedings in Northern Ireland, and then there's a jurisdiction challenge. There's been a big fight over which court should actually proceed. So that actually is several months then, and it's quite costly as well, just resolving which court should actually hand over dispute. It's not even addressing, it's not time and money well spent on the underlying dispute.
Yeah, important not to get wrapped up in that satellite litigation that can cause you lots of cost and problems and no real benefit. And one area we've seen as well that we think sometimes gets overlooked is trade compliance in the supply chain. Businesses trading internationally, in my experience, should have a compliance program in place to make sure they don't fall foul of financial sanctions or export controls. You'll be aware certain goods can only be exported under a government license, and the seller has to provide details of its customer or the end user if that person's different. Now that usually applies, or mainly applies, to military goods or goods that have a military as well as a commercial purpose. So those requirements won't apply to everything, they won't apply to every business. But what we do see is that financial sanctions have a much wider application. And I think it's important that businesses that trade internationally have policies and procedures in place to ensure they don't trade with a designated sanctions target. And that could be an individual, it could be an entity, in some cases it could even be an entire country or a regime. And international trade sanctions, they are truly international. The UN imposed them, the EU, the UK, the US, other countries as well, but mainly those areas. And they're often overlapping, there are some similarities, but they are often different. And it's important, if you're having to deal with trade sanctions, that you're able to have a policy and a procedure and a compliance program that deals with that. And again, in terms of the consequences, breach of sanctions is a criminal offence. There is a regime where you can have a civil penalty, so a monetary fine. But what you do see, I think, Nick, as well, is where you've got sanctions obligations and contractual obligations that sometimes come into conflict with each other.
Yeah, that's right. I think it's always worth, again, bearing in mind that, a sanction can impact the ability to perform a contract. But again, when you go back, these are the types of things that actually you can contract to minimise that risk. So sanctions compliance, you can have with your counterparty that's a contractual obligation, but you have to comply with, sanctions regimes that are in place or new ones that may come in. But also, again, if you have a supply chain, it's about knowing who's in that supply chain, especially if it's international. Companies can be based, in various jurisdictions, and again, with various different ownerships and things, and knowing what that supply chain is, but also ensuring that those obligations and to comply with sanctions that cascade down the supply chain. I also think it's important to remember that sanctions can be imposed at short notice, so they may not be in place. May not be impacting the agreement when you enter into the agreement. So it's then considering, what happens in that scenario. So again, you can put contractual mechanisms in place. So if something does occur that means that you can't perform under your contract, then there's provisions in there. So it may be that you are able to suspend performance without any financial consequences. Ultimately, it may be that you are able to terminate the contract. And I think, as we often talk about these things where it's the possibility where there are sanctions may come in, and it may be that it's not entirely clear whether that bites in relation to you. And then you've got that issue of, well, am I breaching the sanction, or will I breaching my contract? So you could be cautious and think that you're complying with the sanction when really you don't have to, and you're breaching your contract then and potentially face a claim. So again, at that point, it's often where you need specialist advice to really consider what your obligations are.
Particularly, I think if you've got a risk of secondary sanctions, the US in particular, that do that, and there's been movement recently in terms of the so-called blocking regulation, and I think knowing where you are in that framework and layering over that the contract that you've got and trying to find a way through without breaching any sanctions and without breaching any contracts and trying to get everybody broadly on the same side.
Exactly.
Is the way. Thanks, Nick. That's really helpful. So Claire, we've talked about the roles in the supply chain for regulatory purposes and the sorts of contractual issues people need to think about. What do you need to do, or what do companies need to do to make sure the product is being sold lawfully in an overseas jurisdiction?
Mm-hmm. So obviously, once you've identified your role in the supply chain and the specific legal obligations that apply to you and your commercial partners, you can then work out what you need to do to legally place the products on the market. As I said, different regulations apply to different products and it can vary amongst jurisdictions. A really obvious and easy example at the minute is the difference in the UK and the EU as a result of Brexit. So as a result of the end of the Brexit withdrawal period, as of 1st of January 2021, there's now 36 new product-specific regulations. Please don't panic, anybody. They are based on the EU preceding legislation. So it's very much the same principles, but obviously just implemented into UK law. So you need to understand what the specific regulatory requirements are and how they apply to you. So that can include things like your conformance testing and marking your products. So with the CE mark in the EU and currently the UK, and then ultimately the UK CA marks coming, and things like your instructions for use and your, as I already said, marketing, labelling, packaging requirements, that sort of stuff. So as I say, work out where you fit in the supply chain, what regulations apply to you, and then what elements within that you're going to need to consider.
And you mentioned the UK CA mark that, as you say, isn't in yet, but can you give us a flavour of what's coming?
Yeah, sure. So it's recently been pushed again. It's now coming into force on the 1st of January 2023. It does largely mirror the CE marking requirements. So products that previously needed to be CE marked are now going to need to be UKCA marked, as I say, after that date, 1st of January 2023. There are a couple of exceptions. So if you sell specific products, it could apply early. So medical devices and construction materials. So just double check that it isn't going to be something that applies to you early. As I say, you'll then have to deviate. So for European markets, you need a CE mark. For the UK market, you'll need a UKCA mark. So it does mean there might be a bit of duplication in terms of cost and time to get those markings applied, particularly if you need testing from a third party. If you do need third party testing, some products you can self-certify, but if you need that third party testing going forward, you will need the notified authorised body in the relevant jurisdiction to do that testing for you. So for EU products, for the CE mark, you'll need to be an EU testing house, UKCA mark, UK testing house. Thankfully, the technical specs and documentation that you need to supply for both largely the same. So there shouldn't be too much duplication in that respect, but it's just having the right people doing the right testing for you. Okay,
good. And yeah, either understand what you need to do or speak to an expert.
Yeah, absolutely.
I know one of them. We've also found, I think you mentioned labelling, product packaging generally can throw up some interesting issues, particularly I think you said earlier about the sorts of claims that you can make on packaging.
Yeah.
But particularly labelling as well throws up some interesting points.
Yes, it does. So as with the regulations more generally, the specific requirements on labelling and packaging can change in different jurisdictions and again for different products. So you need to work out what applies to your products in the jurisdiction. So find the right regulations that apply and then have a look at those. They will specify what information you need to include in relation to safe use, safe storage, information you need to provide to your consumers. If you need to label your product to say what standards you've met, UK CA marking, CE marking requirements, and if there's particular rules about the ingredients that you include or how you include them, and as you've said, marketing claims. So I've got a couple of examples of this recently. One of our clients was a US client. They were creating or manufacturing health products. They weren't manufacturing. Manufacturer was actually based in China, and then the client was in the UK. So we helped both the US entity and the Chinese entity understand what the British standards were to ensure that the certificates were in place, the labels had all the detail they needed to. It was particularly relevant in this circumstance because whilst the customer was UK based and they actually collected the products from China for us, so they fulfilled the importer role, it then therefore meant that they pushed the obligations on us, making sure that we discharged everything they needed to because they were taking that risk. So our client was subject to massive scrutiny from their technical team to make sure we dotted the I's and crossed the T's for them because they were going to be legally liable if something went wrong. The other example is another food business sector client. So it's a US company that manufacture health supplement drinks. They were looking to expand into the UK. And so again, they had products that were approved by the FDA and already being freely sold on the US market, but they contained particular ingredients that was permitted in the US. Some were restricted and some had to be in restricted quantities to be in the UK market. The other thing there was the health claim point. So they'd made particular claims about what these miraculous drinks could do, and it was about making sure that they had the evidence to back that up. And that's just for consumer protection. We can't mislead consumers in the UK. So if you want to make any health claims, you just need the evidence to support that. So it's just a case of guiding the US company through that process and making sure they understood what they could do and what they couldn't do, and how that differed between the US and the UK.
Yeah, that's helpful. So that's quite a bit on the regulatory compliance issues. What sort of issues from your side do you see, Nick?
So I think we often see compliance issues arise when there are supply shortages. So this often puts pressure on us to meet contractual requirements, and it may mean then that parties are looking to source, materials or goods elsewhere. This is something obviously we've seen a lot in the last couple of years with the pandemic, and as we see, there's ongoing logistical issues, there's been shortages of raw materials. So when issues with existing contracts have arisen, we'll often do detailed reviews, working with our clients, then looking at those contracts. And often what we try to look at are 2 points. So firstly, it's trying to work out where there's some flexibility in those contracts. So where is the room for interpretation? Where is the room to negotiate? And then the second point is looking at, well, where are the pressure points and where are the break points? And I think then taking those two together and obviously applying it to the factual situation, we can then work to develop strategies and put options in place then to try ride out the crisis.
And can you give us some practical examples of pointers of that sort of thing?
Yeah, so I guess we often talk about the worst case scenario, and really what we're always talking about is trying to plan ahead to mitigate risk then. But in reality, you can actually avoid lots of those issues just by taking action quite swiftly and getting that advice early, working out what your risks are, working out what the liabilities are. And again, lots of the issues we saw in the last 18, 19 months during the pandemic, it's actually parties work well collaboratively together in a crisis. And I think that's always key. We talk here about disputes, but really what we want to do is avoid those disputes. So I think it's keeping that open dialogue, obviously without waiving any rights or compromising a position, but seeing where possible, if you can work with your suppliers, if you can work with your supply chain to try and overcome those issues. Obviously, if you can avoid disputes, it means that you have good working relationships going forward. It means you don't have time and costs on disputes.
Which is a good thing.
Yes.
But it's inevitable that despite everybody's best efforts, sometimes things will go wrong. So Claire, if I can turn to you again, from your perspective, what are the regulatory red flags to be looking out for?
Yeah, so unfortunately, breaches of regulations tend to be criminal offences. So as a result of breaching regulatory requirements, if there is action taken by the regulator in the relevant jurisdiction, you can be prosecuted through the criminal courts. So it does result in a fine and a criminal conviction. So obviously then the negative press and PR that's associated with that is something to bear in mind and overcome. And you can also practically have to then affect potentially a multi-jurisdictional product recall or withdrawal, which is no mean feat.
And I think that probably brings in the dispute side as well, Nick. It might cause you, the recall might cause you a problem with the supply chain.
Yeah, definitely. I mean, if you're having to recall a product, obviously it's one of the worst case scenarios, really, and that can have a wide impact on a number of different issues, a number of different areas as well. So obviously the party that ultimately ends up recalling the product and delisting the product, they'll no doubt be looking to pass on the losses and their costs of doing so to someone. The supplier who supplied the goods, well, they may not be at fault actually. It may be that there's various component parts that they put together down the supply chain. So then the supplier may be looking down the supply chain. Again, where's liability? Who should actually carry these costs then? Now that might not be very clear cut. It might be that again, there's timely, costly investigations that need to be done. Experts need to be involved to work out down the supply chain, where did something go wrong? If consumers are involved as well, if goods are being sold to consumer, obviously you may have claims from consumers. And also just PR, as you mentioned, it's often, terrible for PR. And we see with consumers, especially at the moment in food and drink, if there's any issue with those items, they're quick to be on social media, to be on Twitter, taking pictures, and things spread really quickly. But sometimes as well, that can escalate and goes beyond just reporting what's happened and become, defamatory comments and really damaging and having financial impacts on brands as well. I think we saw this relatively recently where there was a faulty food product. So supermarkets pull it off the shelves. They then claim all their costs from the supplier. Obviously, you've not really got much negotiating power with the supermarkets, who may be a big client. There's then the investigation down the supply chain. There's disputes all down the chain then about who's liable. And again, we did see in that scenario that this faulty product was quickly spreading on social media, and the damage to the brand was fairly high.
So in that situation, what sort of contractual remedies should people be considering?
So again, it all goes back to right at the start, thinking what remedies should you have in your contract and what do you do when things go wrong. So ideally, what you'd have now is a fairly advanced dispute resolution process in your contract. So parties aren't immediately rushing off, going to court or going to arbitration. So it may be that you have escalation provisions in there. So this means that, it goes to, operation managers, it goes to mid managers, and ultimately it can be escalated up to perhaps, the senior management. But each time it's trying to ensure that parties have an opportunity to see if they can work together to resolve it. If that doesn't work, it may be now that you want to have some formal alternative dispute resolution mechanism in there. So something such as a mediation, where parties can have a third-party mediator who actually acts as a facilitator, goes between the parties on a private, confidential basis. Nothing said to the mediator can be used in any court or arbitration proceedings. See if there's a middle ground, seeing if the relationship can be kept going forward. So that a mediator will discuss with both parties, and ultimately they don't make a judgment. So if no agreement's reached, it may be that it has to progress. And again, we saw during the last 18, 19 months that historically mediations would have been face-to-face, but actually they've worked really well on Teams and Zoom with parties, again, all over the world. So I think that's something that will probably continue going forward. It gives parties just that extra opportunity to see if matters can be resolved. Ultimately, things may not be able to be resolved. And if that's the case, then again, it's looking back, what did you agree at the start of the contract? Did you agree a court process, or did you agree such as an arbitration? Arbitrations are very popular in international supply contracts. One of the big benefits of arbitration is that they're usually confidential. So it means that you don't have to air your dispute in public. And obviously there's benefits with that. It might mean that actually helps as well in terms of the ongoing relationship.
Yeah.
It's worth just noting, obviously, what Nick's talking about is the civil sanctions and remedies when something goes wrong. As he said, it's about you being able to recoup funds further up the supply chain if there's an ability to do so. But actually, if you're prosecuted by a regulator under your role that are specified in the regulations for breaching them, there's little you can do about that. It is going to be your entity that is prosecuted through the courts. You will have to pay the fine in the first instance. So whilst it's great that there's a remedy to potentially recoup some of those funds, it is you and it's your PR that's going to suffer for getting it wrong, unfortunately.
Yeah, absolutely. And we'll come back to that thought in a moment, but the enforcement, if you do get a judgment or you find yourself on the end of a judgment, how does that work?
Yeah, so this is a question that we're asked a lot at the moment, obviously post-Brexit as well. And whilst the rules have changed slightly, overall, we've not seen any issues at the moment. So basically, when we're enforcing in Europe or when European judgments are enforced in England, there's more hoops to jump through, but it is still possible. And so the UK did apply to be admitted to the Lugano Convention. That's not been accepted yet, but that may make things easier in future. But this has been why lots of parties, there's uncertainty there or more hoops to jump through. So lots of parties have been agreeing arbitration instead. So things like Brexit hasn't affected at all the enforcement of arbitral awards, whether in Europe or European awards in England. So that's been a continued popular choice for international supply contracts. That's governed by the New York Convention and is easily enforced in a number of jurisdictions.
And you mentioned there the Lugano Convention. What would that mean if the UK were accepted as members?
It's just a simpler process. It's basically, it means that you'll be accepting the judgments automatically. You won't have to go through the process of getting them recognised.
And so just coming back to UK, you were saying then about, quite rightly, about the difference between a civil procedure under a contract versus being prosecuted if your company's committed any offences. How would that play out in terms of, as you've said quite rightly, you can't shift that liability away? How do you deal? How's the best way of dealing with that?
Yeah, essentially, if you are found to have breached regulations, or there's an allegation that you've breached regulations, obviously the first thing to do is understand what the regulator is saying you've done wrong, or what the potential pitfall is, and then conduct a thorough internal investigation, understand where your liability might lie, or what might have gone wrong. Obviously, as I said, you can't pass that blame if ultimately you are responsible, but obviously doing a detailed investigation will allow you to understand if you do have a defence, or if you do need to accept liability. Through the criminal court, certainly in the UK, you can obviously defend a claim, plead not guilty and try and defend the position, or you can plead guilty and put in a plea and mitigation. So yes, we got it wrong, but this is the reasons why you shouldn't punish us too harshly, and see if you can negotiate the best outcome possible in terms of any fine or enforcement action.
Try and give your side of the story.
Yeah, absolutely.
Yeah. So we better not leave people on the basis of going to prison and having contractual disputes. So if we could try then on an optimistic note, what would you give us some top tips to remain compliant and stay out of those sorts of difficulties?
First, plan properly in advance. That's got to be your default position. Make sure you understand what you're doing before you're doing it. So, as we said right back at the start, what are you trying to sell? Where are you trying to sell it? What are your legal obligations depending on where you sit in the supply chain? Have you got the right contractual provisions at the outset? It just makes everything more simple going forward. Maintaining that compliance is obviously important. So you need to be thinking about continually monitoring and auditing what you've got in place. You can't just set something up and hope it carries on working. What are you doing by way of spot checks? How do you know your supply chain partners are doing what they're supposed to be doing? How will you spot something if it goes wrong? And you need to have all of those mechanisms in place so that if something does go wrong, you can jump on it and get it sorted really quickly. I think we've discussed this before, Nick, haven't we? Things are going to change, regulations are going to change. You're going to need to be aware of that and update your contracts as well.
Exactly. I think obviously people have long-standing relationships, might have very long supply agreements, and actually what they originally contracted for may change over time. And it's always worth checking, well, actually, what does the contract say in that? What does it reflect what we're doing in practice? And does it have the right protections in case things go wrong? Again, people aren't wanting to have those discussions, but things may ultimately go wrong.
Yeah, and I think that the other top tip I would give is make sure that you've got specialists available to help you with horizon scanning. That could be people in your own organisation, it could be specialist lawyers or, other advisors in jurisdictions to know what's coming. Because if you can be forewarned, you're forearmed, aren't you? So if you know what's coming down the line, then you've got time to make sure that you've got your ducks in a row and that you can be compliant when the rules change. But also, if you're looking at a long lead-in time for bringing a product to market, say that's 6-12 months, for example, it's no good complying with what applies today if the rules are going to be different 12 months down the line. Don't waste your time doing it twice. Know what you're going to have to comply with down the line. And as I say, that auditing, monitoring is really important to make sure that you keep complying, essentially.
And I think from your side, Nick, a word you've used quite a lot in the last half hour or so is relationships. Yeah. And it's keeping those relationships going with your customers and your suppliers.
Exactly. I think lots of, I deal with disputes day in, day out, but lots of these disputes could be avoided had people just had conversations earlier on. It's identifying when the issues are starting to arise. And then before it's too late, before, things have got out of control and the parties are then, too far apart, is having those discussions and seeing, again, parties entered into the agreements wanting to work positively together. So it's seeing, identifying it early and seeing if what can be agreed to really prevent anything escalating and getting out of control.
Yeah. And if you can't, taking action. You know, do you need to change your supply chain partners to make sure you are fulfilling your legal obligations and staying compliant? If you are spotting an error and it isn't reconcilable, cut your losses and move on with somebody that can help you with that compliance.
Yeah, thank you. Well, that has been a fairly swift canter through quite a lot of topics there. I think we've got one or two questions from the audience. The first one, Nick, if I can turn to you, is why would companies choose England as a jurisdiction and English law as a governing law?
So I think the answer is largely historical. So I think English law is well developed. I think lots of common law jurisdictions obviously base their laws on English law. So I think it is just well respected around the world. I think it's seen it's business friendly. I think businesses often see it where in other countries as some independent law. And I think in respect of jurisdiction, I think the English judiciary, they're very well respected. They are well known for their independence as well. So I think that it's seen as a safe pair of hands. I think the court processes as well. I think, you know, sometimes in England we may be frustrated or think that they're quite slow. But then when we speak to some of our friends in different countries, actually our processes are fairly swift comparatively.
And again, going back to the example you gave earlier of your East Africa client with a customer in Switzerland, but an English lawyer is advising on it. And
obviously one of the things is the English language. It's one of the things that's common between a lot of countries as well. So it means that you can contract and do business. Lots of people do business in the English language. So when it comes to disputes as well, when having English law, having disputes resolved with an English language proceedings, it's often seen as a neutral choice.
Yeah, and popular for that reason.
Yeah.
Okay, that's helpful. Thank you. And I think we've got one other question, and this one I think is probably better for you, Claire. I don't think Nick would thank you for asking this. So if something's got a CE marking today, and the person wants to put it on the market in the UK in 2023, will it need to be UKCA approved by then? Can it use its CE marking?
So it'll depend on the circumstances. As I said earlier, bear in mind there are some products that will need UKCA marked prior to that date, so don't fall foul of that. Just double check that your products aren't in those categories. If something is already on the market as at 31st of December 2022 with a CE mark, that's fine. You don't need to wake up on the 1st of January, take everything off the shelves and relabel. That's not the point of it. But anything new being placed on the market post 1st of January 2023 will require that UKCA market. And when I say new, I don't just mean a new product line, I mean new batches. So anything that hasn't previously been on the market in the jurisdiction will need UKCA marking. But no, you don't have to pull everything off the shelves that are CE marked before.
And relabel it. Good, that's very helpful. Thank you. And particularly helpful answer, I think. Well, thank you everyone for joining us. We will be sending out some follow-up materials to you, including a link to download the Made for Trade report. We're about to say this, but it really is an interesting read. And I think there will also be a video available of this if you've missed any of it. This webinar today is the first of the series. Our next one is on the 16th of November. You'll be pleased to hear it won't be me. It will be other people talking about the global supply chain disruption. I hope you can join us for that. If you have any other questions in the meantime on the topic we've spoken about today or related to international trade generally, please do reach out to us and we would be happy to pick up with you. Thanks very much.